and to put into process that sort of roadmap that ensures that your loved ones are taken care of in the best possible way upon your death. So that, in a sense, is what holistic estate planning is. And when we say holistic, we mean not just one aspect of the law or one aspect of your rights. It's holistic. So we look at everything in a very broad perspective. What are the implications from a tax perspective on the decision you make? What would be the implications from a legal perspective? What would be the ramifications on your family, or perhaps the people you are dependent on, or who are dependent on you? In this way, then, one is able to structure one's finances and assets in a way that seeks to reduce the major costs on death. And we all know now that the three most significant costs that we always have to face, that's besides our liabilities or daily expenses. So besides your vehicle finance, the bond on your property, your DSTV bill, there are three very critical costs that one has to take into cognizance of. And that is the executor's fee, so the 3.5% that the estate would have to pay to the agent or the executor who's winding up the estate, capital gains tax if assets have to be sold to liquidate the estate, and of course estate duty, the wealth tax that SARS imposes on us for all estates that are in excess of 3.5 million rand. And then of course there are legal battles that often ensue in our family lives or as a consequence of certain decisions taken, and the focus then is reducing all of these costs, reducing any potential legal battles that may arise, and therefore leaving sufficient funds for one's family and avoiding a situation where your family is financially in strife. So that in a nutshell is what estate planning is. What are the mechanisms of estate planning? In other words, what are the tools of estate planning? And I'd like to suggest that the main tools of estate planning are your will, donations, perhaps to an appropriate organization, because there are tax benefits, insurance, retirement policies, and of course, having a trust. My focus is primarily on, for tonight's discussion, is primarily on wills and trusts. Now, we need to ensure that our wills are drafted so that they relate to us and our circumstances. The will is a very useful tool to ensure that we secure our loved ones, and also, very importantly, to secure our minor children. So our will is a very useful tool in ensuring who the guardian of your minor children would be in the event that both guardians have passed on. And that is something that many families forget to account for. Then it's the will has to, very importantly, would appoint the executor in the estate and nominate heirs of one's choice, and avoid a situation where funds due to a minor child are put into the Master's Office Guardian's Fund, and then you sort of lose control over the management of those funds for that minor child. So will is useful for that. Wills are also very useful for setting up testamentary trusts. So if you have certain beneficiaries or heirs who are incapacitated in any way, whether it's mentally incapacitated, physically, or even in terms of legal incapacity, where they are still minors, a testamentary trust is a useful tool to include in a will to take care of those short-term issues. The other thing that I would like to, the next issue I've been tasked to deal with is in regards to trusts. Very often, many of us are trustees in a trust, and we have no idea what our roles and obligations are. And I'd just like to emphasize that it's critical that we become more aware of that role and obligation that we hold. It's an office that we hold, and it's something that we need to manage appropriately. As a trustee, I think the first rule is make sure you have a copy of the trust deed. Very often, trustees don't even know what the trust deed looks like. So I think it's important that you have a copy of the trust deed, that you understand what your role and responsibilities are in terms of that trust deed, and what your obligations are. It's very important as a trustee to keep abreast of any changes that take place in terms of the tax laws or perhaps even trust laws. So the moment there's a change in tax rules or trust laws, we need to be aware of that because we need to comply with them. Very often, our lack of compliance due to our ignorance lead to certain penalties, and that creates a huge disadvantage to the trust or the assets in the trust, or even dwindles down to the beneficiaries. You must have a personality that is comfortable to deal with paperwork. The trustee's role is very admin based more often than not. And if you find that you aren't able to deal with the paperwork appropriately, you're going to find that there are certain things that get neglected, and there could be circumstances in which you are held personally liable if certain things are neglected, and you don't want that situation to arise. It's also important as a trustee to understand or to ensure that the assets in the trust are protected. If there's a property, make sure there's some degree of insurance or some sort of cover to protect that particular property. That if there are occupants of that property, that there's a lease agreement in place, that the tenants are paying in their rentals on time. That also that important dates are diarized so that you know all the roles, responsibilities, obligations are appropriately complied with. It's important for trustees to have regular meetings so they are kept abreast of what is going on in the trust or in terms of the trust assets, and it's important to minute those meetings. Very importantly, and I think this is really neglected in our community, or just in terms of trust law, is that we don't review our trust regularly. A trust deed is a document that requires regular review because there are, as I said earlier, changes in trust law or tax laws, and one needs to make sure that your trust deed is appropriately geared to deal with those changes. And I like to say we need to give the trust deed a medical checkup in a sense. So that's what a review is. A practitioner, a fiduciary practitioner, is going to go through the trust deed in detail, ensure that it still is relevant to the circumstances of the beneficiaries, and amend certain clauses if necessary. So that's very important. We've had many instances also where trust deeds date of termination comes up and the trustees are totally unaware of that. So those little things need to be dealt with. So reviewing your trust deed is extremely important. And also that also helps you to understand what your obligations are or what they ought to be, and avoids a situation where a potential creditor or even a disgruntled spouse can declare the trust to be a sham trust. And that's something we want to avoid, of course. So that's what I would like to sort of just emphasize on in terms of trusts, the importance of being aware that these are critical tools in this entire journey of estate planning one's estate, and we need to give more attention to that. Very quickly, and I know my time is almost up, I'd like to just touch on something that's very significant for all of us, and that's the process of winding up the estate. When a person dies, very often the family members are at a total loss as to where to begin. And I'd like to just give you a quick snapshot in terms of the process so that there is some degree of understanding and you can understand how then this unfolds into this entire estate planning discussion. So the first step is that the estate has to be reported, and by reporting the estate at the Master of the High Court, an executor is important. Having a will fast tracks this process because your executor is already nominated. The Master doesn't have to go through a process of determining who the executor ought to be. The next step then, of course, is to advertise a little notice to the advertisement that appears in the Government Gazette and in a local newspaper, and that's a notice to debtors and creditors. One would have to open up the executor would have to open up an estate late account, contact SARS, because as I always say, there are three things certain in life: it's life, death, and SARS. SARS needs to be contacted and informed, especially if the deceased was liable for tax. And of course, debtors and creditors are contacted so that that entire process of investigating, verifying, and valuing the assets and liabilities of the estate assets are undertaken. The next step then is to lodge the L&D account, L&D meaning the liquidation and distribution account. In summary, the liquidation and distribution account sets out the assets and liabilities, and then of course the distribution part deals with the who gets what. And that very much is linked to either the will, or in terms of if there's no will, then the heirs that are identified by the Master of the High Court. Thereafter, once that account is approved by the Master, a second advert is placed in the newspapers and the Government Gazette to confirm or to advise the public and creditors that this L&D account is available for inspection, and if anyone has any objections or any claims that are not lodged, this is their second opportunity to do so. Step 4 is then, once the Master approves the account, of course, and there are no objections to this account, it's only at that point that the assets are distributed to the heirs and the balance of the creditors are settled. It's also at this point that the agent or the executor is entitled to their fee. So up until this point, the agent or executor has to more or less invest a lot of time and resources to get the estate to this place. The final step would be to lodge the proofs with the Master. By proofs, I mean proofs that the assets have been distributed to the heirs and that the creditors have been settled. It's at this point that the Master will give the thumbs up to say that this estate is now finalized. On a good day, pre-COVID, a simple estate would take approximately 18 months to wind up. Of course, now that we're in this entire pandemic, the Master's office is under extreme pressure because they are experiencing shortage of staff. Obviously, there's a huge influx of work coming in. So this entire process is so much more staggered. So you need to be aware that this process is taking much longer to finalize. So in a snapshot, that's a process of winding up an estate that we all need to be aware of, and therefore ensure that our estate planning is done effectively so that we can reduce the conflicts that often arise during this process. That's all for me for now. I will take further questions later, and I hand over back to our chairperson. Shukran.
Jazakallah. Thanks, Rumana. Thanks for that overview. I think it's important to, about a year ago, I decided to get my trust deed analyzed and interrogated, and I realized that it kind of had an expiry date. And I think it's critical that we all go through our trust deeds to ensure it's updated as such. Just for those individuals that have joined us in the last few minutes, my name is Faizal Suleman. It's a program really brought about because of the pandemic and the number of younger people that were passing away. And of course, it becomes a problem, especially for the deceased families and the spouses and that type of thing. So I thought it was very critical and important for us to really engage a whole lot of specialists to give us an overview. And obviously we can continue with individual programs thereafter. That was Rumana, who's an attorney, and she's got 14 years of experience in the legal field and specialized in estate planning and wills and trusts. We have Faizal Suleman, who's an experienced CA and auditor. We have Ashraf, who's also a senior attorney. Ahmed Seedat is a family business specialist, and he's author of 2 books relating to family business succession, which I think is important. Raeesa Bayat is a corporate relations manager in Durban in the office of Albaraka Bank. And I just would like to mention before we get on to the next panelist, tomorrow, it's the 14th of January, we basically have a webinar to understand the security features of the messenger apps. And on Saturday, the 16th of January, we have leadership characteristics. So if you want more information on that, you could actually look at our Facebook page. That's the Minara Chambers Facebook page. I'd like to now ask Faizal to talk to us as a chartered accountant, and how does one react to a spouse's demise, a spouse that passes away? What actually happens? How does it work? Because I had a close friend of mine that passed away on Friday, and suddenly you realize that you're going to have the bank accounts being frozen, and businesses have to be maintained and run. And how does one do all this? Especially where the spouses really don't get involved in the business, don't get involved in paying any bills. A few years ago, my brother-in-law passed away suddenly. Played squash, got home, and he died. And one couldn't get into his cell phone, one couldn't get into his laptop. We didn't know the pins, the passwords, and that type of thing. So one has to prepare for all this. So I'd like to call Faizal to talk to us. Faizal.
Assalamu alaikum. Auzubillahi minash shaitanir rajeem. Bismillahir rahmanir rahim. Yeah, in the last week, I think alone, I've received a few calls from people where spouses have passed away and the family is in limbo and they don't know much about the business and what to do. How do we keep this business running? Each business is unique. It has peculiarities. I mean, if you take, for example, a pharmacist, you can't operate the business without a pharmacist present. A doctor, you can't have a practice open without having a doctor in place. And likewise, various other businesses are unique in their own way. So, when you think about all of this that has been happening, it makes you wonder, firstly with our clients. I start with myself first. I mean, I'm a sole practitioner. So what happens to my clients in the event of my death? What do I have in place to ensure that they are secure and with the knowledge that, that their affairs are going to be taken care of? It's one thing that I have staff, but you need someone that's going to take over my place. So with that in mind, each person needs to consider from a business perspective, what do they need to do? Now, generally, when we meet with clients in terms of signing their financial statements, we would go through certain matters and check that they have a will, and do their spouse and children, adult children, also have a will. These are just the basic stuff, but we need to take it a step further. So with that, my general advice to my clients is to prepare a personal information file. Now, what would be contained in that personal information file? Now, the list can go on forever. There's so much. Each person is unique. Each of their affairs are different. So, there might be a simple basic, or there might be a complex with all sorts of things, various entities that the person may be involved in, trusts, etc. So I'm just going to go through quickly a list of things which I think should be included in your personal information file. The first part, obviously, is your details: full name, ID number, passport number, income tax details, your parents' information. Rumana will tell us that that's required in terms of the estate. You wouldn't think about that, but you need that information. So I would document your parents' information: full name, ID number, date of birth, where they were born. These are all information that would be required. Your marriage information, whether you're married in antenuptial contract or community of property. Your spouse details: name, ID number, he's registered for income tax, their details. The next one is the name of all entities that you would be involved in, the shareholding that you have, your business ownership, whether it's sole proprietor, partnership, company, etc. You may have trusts. Rumana has gone through the details in terms of what you need to do with regards to your trust. But who's your trustees? Just the details of your trust, the name, the trustees. If you're operating a business, there's also the issue of, do you have key man policies? If you're in partnership with others, are there buy-sell agreements? If you're a sole proprietor, what can you do to protect your business, to ensure that in the event of anything happens to you, what will happen to this business going forward? And in my practice, as an example, I have what I would call a business continuity agreement. So I have an agreement with another practitioner who, should something happen to me, whether I'm sick, disabled, or die, that person steps into my shoes, and effectively my clients are informed, this is the person now that's responsible for your affairs. And the whole idea of this is basically to continue to ensure that the business continues, that the practice continues, that the staff retain their jobs. So, it's always something that you need to consider. What next? What about your original documents? You have a whole lot of things: your original will, your title deeds for your properties, your ID, your passport, marriage certificate, your marriage contract, vehicle logbooks, tax information. If there's any sureties that you've signed, it's important that you document this, because it's something that you need to, your heirs, your executors all need to know about. You don't want to be surprised by some surety that you signed 20 years ago, either for a supplier or for someone else's debt, and this comes up now and it's a claim against your estate. If you have a safety deposit box, that information as well, put that into this information file. Your list of personal advisors, your accountant, your attorney, your insurance broker, who your executors of your estate are, your religious leader, if there's someone that you want specifically to attend to your last rites, document that. Then a list of assets and liabilities. Now this needs obviously to be updated regularly, and as much detail as you can put into the document, update it at least annually, but I would suggest at least whenever there's a transaction that's taken place which is significant and affects your assets and liabilities, put that in there. The details of your insurance policies, retirement annuities, and who the beneficiaries are. Your current, if you're employed, your current employer details, membership of any clubs, professional associations, gym, your bank details, your credit card details. Now, the security of this information is obviously very important as well. And there are softwares available that you could use that may protect the information that you put a record in there. And I would suggest do some research in terms of that as well, and try and put that information in a secure. Your simple thing like your utilities, your electricity account, your cell phone accounts, your landline, the information relating to that. People need to know after your demise. If you were the only person responsible for paying for these things, you need to then take that into account, document the details. There may be usernames and passwords that you need to access these accounts, etc. All of that, put that into this personal information file. Bequests and charities. You may have certain specific bequests that you want to make, document it in this file. Then we come to the IT and social media side of it. If you've got accounts in WhatsApp, LinkedIn, Facebook, etc., what about those sort of things? Your login details relating to all of this. Again, you need to make sure that information is secure. So I would suggest that all of that needs to be documented. If you have a personal website or email address, the details of that to log in, to be able to log into that information, should your spouse or your executor needs that information and access. Your laptop, your computer, your cell phone, the login details relating to that. You may have softwares that you purchased, your username, your passwords relating to all of that. Then you've got things like loyalty programs. You've got frequent traveler programs, your store cards, all sorts of loyalty cards that you may have. The details relating to that, again, just to keep a note with regards to all of that, usernames, passwords. And finally, your burial requests. You may want to be buried in a specific cemetery, and what your requirements would be in terms of your last rites, etc. I would suggest that all that be documented in the file. That's in a nutshell what my recommendations are. It's not exhaustive, and there may be things that may not apply to you, but basically, I've just summarized that sort of thing. I drew up one recently, and it came to almost 24 pages for one of my clients. So that's it for me.
Thank you, Faizal. Tomorrow morning, I'll have to sit with my wife and get all these things sorted out now. It's amazing. There's so many things that one has to take into account, and I've actually not been doing that as well. I mean, I need to. The only thing, I'm not going to give her the pin for my phone, but other than that, I'll have to discuss everything else. I'd like to call upon Ashraf Essop, who's the senior attorney from Gauteng, who's also one of the directors of the Minara Chamber. And I forgot to mention, Faisal is also one of the committee members of the Association of Muslim Accountants and Lawyers, Amal they call him. And they are a very good resource as well, if anyone wants to contact them. Ashraf?
Assalamu alaikum, and thank you for the opportunity. Thanks to Minara for arranging this very important topic. What I'd like to do is try and give some practical experience or practical steps that one can take, given there's a pandemic, given the fact that people are caught unawares, and what happens if you don't have a will. Well, if you don't have a will, then your estate will devolve in terms of the rules of interstate succession. Now, those are very clear, and they are set out in the law. The surviving spouse gets one half, and then she gets a child's share as well. But without going too much into detail of how that estate will devolve, it has to be appreciated that you can always approach the master and say, to devolve this estate, we the heirs consent to a redistribution, and we agree that it should be along the lines of Islamic laws of succession. A very interesting question now is the recognition of Muslim marriages or the setting aside of the Marriage Act and the Divorce Act because it discriminated against Muslim marriages. So you might have more than one spouse, and already legislation has already recognized Islamic marriages in that sense. And so there's no discrimination between the spouses. But how would you be able to get an Islamic marriage or an Islamic marriage recognized for the purposes of inheritance? Well, the master is accepting a certificate by a religious council, Jamiat or otherwise, giving directions as to who would get what. And obviously the heirs would then sign the redistribution agreement. So that's just a side note on a very practical level of some of the things that you could face in an emergency. Now, let's say you're really worried today and you don't have time to see your accountant or your attorney and you want to do a will. Well, there are certain basics that one has to adhere to make sure that that will that you're executing, which you can do on your own, has to be legal for it to be recognized by the master of the High Court. Otherwise, it will be set aside. So for obvious reasons, the will has to be in writing. So an oral will not be recognized. It should be dated to avoid confusion. Very, very importantly, witnesses cannot benefit under a will. So you can't be a witness and an heir. And witnesses cannot be nominated as an executor or an administrator. If they do, then that nomination will be void. The will has to be signed on every page by the testator as well as the witnesses. And it should be clear and readable, whether printed or handwritten. Now, the pages preferably should be numbered, and signatures should be as close as possible to the last line. Now, let's assume you're unable to sign that will. You are giving directions, and the person writing the will, as we said, shouldn't be the heir, and you're unable to sign your normal signature. Well, you could put your thumbprint, or you could mark with a mark, an X, for example, but that then has to be in front of a commissioner of oath, because the commissioner of oath now has to certify that he satisfied himself as to the identity of the testator and that the will was signed on such and such date. And he also has to put his certificate. So that's very, very important. And just on a practical discussion further, the executor has to be somebody that is widely respected. For example, if he's a family member that already has difficulties with your wife and children, then that would not be a wise choice, because on a very practical level, you, the wife, and the children will require assistance and maintenance and support while the will is being wound up. And it's easier to ask the father or the dad for whatever you want, but it's more difficult to ask an executor, because he might not think that that particular item is necessary. And so one has to avoid conflict. In the event there's a minor will or the estate is below 125,000, then the long process of winding up is unnecessary. The master will give you letters of authority, and you would be able to quickly put an inventory together for the master and say to him, okay, I've distributed it according to A, B, and C. So there could be a will, but if the estate is below 125,000 Rand, the process is simpler. Very importantly, executors should be nominated, but you should include what we call the power of assumption. That means if that executor is unable to carry out the duty, he can assume somebody else. And very important, you should put in a clause that they are exempt from furnishing security for their duties. And in the event that you find that you have assets abroad, that also has to be very, very important, because to take into account for your estate planning. The reason being that the South African courts or the South African master will wind up the estate in terms of the assets that are found locally. He doesn't have the power to do so overseas. So again, there is an added necessity for the executors to be able to collate the estate correctly and to wind it up in the foreign jurisdiction as well. Rumana has touched on this, and I think it's very, very important to understand that the 3.5 million Rand is your basic cutoff. Anything above that is taxed in cash within 90 days. So 25% of the balance of the estate, of the residue of the estate, is taxed by SARS. So very, very important for you to do a proper calculation. If you have a look at your assets, if your house and one or two insurance policies that are there, or what we call deemed assets, then that also forms part of your estate. So very, very important to find a balance between what you're going to have at the end of your estate, and you can do a calculation and then do some very wise estate planning. But basically, those are the requirements for a valid will. The other areas have already been covered, and that's where I'll leave it. Thank you very much.
Shukran. Thanks for that, Ashraf. I'd like to now ask Ahmed Seedat to talk to us about succession planning and in small businesses and, of course, in family businesses. Ashraf. Sorry, Ahmed.
Assalamu alaikum wa rahmatullahi wa barakatuh. Good evening to one and all of you.
Ahmed, can you put your camera on, please? Continue, Ahmed.
Assalamu alaikum wa rahmatullahi wa barakatuh. Good evening to one and all of you. There's two aspects of understanding succession in business. One is going to do with the successor of the business coming in, which is normally when there's as you wanted to know about the sole proprietor or a partner coming to the business, or a director coming to the business, whether there's succession assigned for those purposes. The other is succession management.
Ahmed, you're not too clear. Can you, just not very clear. Can you talk a bit louder or a bit closer to the... mic.
Am I much clearer now?
Yeah.
Okay, sorry about that. I said there's two types of succession in business. One type of, the first one is the successor to the business at shareholder level. The other is the succession in the management team, and it's how you handle the succession in both aspects of your business. Now, what we're finding that presently in sole proprietors or small businesses, once the succession takes place, when the demise of the shareholder or is the demise of a partner, we find that the family, the first things they do is that they want to replace the management team. And what we find is that the biggest issue is the management team know the business, and we find that family members thereafter have difficulties. And what we're finding is that the entire business landscape is changing, and with leadership challenges and family businesses, what we're finding is that the management team, they are not really aligned to the family values the moment there's a demise in the family. And the first thing that you need to do is that you need to be aligned with your management. Your family needs to be aligned with the management. They need to be told um, about their job security. They need to know to be told, who's the person that's going to be accessible to them, and how their career path is going to be in the family business. And what we found is that when the next gen comes in, that means at successor level, at the shareholder levels, we find that we need to give the new generation that coming, we need to give them purpose. And purpose to understand exactly what are they going to do in the business. The second thing what you need to do is that you need to educate them of their roles in the business. You don't expect them to join the business and say that you're in charge. What are you in charge of? What is your roles? What is your responsibility? And they need to be accountable to the family per se. But presently, we're finding that there's a great divide between young graduates and family businesses. Graduates, when they come out of university, when they come into family businesses, the culture is totally different. The education system is all bent around them checking boxes, seeing the theoretical aspects of business. But those family people that have been in the business is the culture and the way the businesses operate. So what we find is that void, that gap needs to be bridged. And we're finding that when that gap is not bridged, there's a lot of resentment between the management and new entrants of family members coming into the business. So what we're doing is that due to the prior to the pandemic, we came out with a book um, based on preservation of wealth. It's a very easy to understand book on how family this is the book on how family members become aligned to the business. And what we found is that the first thing we make them understand who are the key partners of the business. What is the business selling? What is the revenue stream, as well as the cost structures? And we're finding that the main issues regarding the new generation that's coming into the business, when they're in a state of shock, and it's very it's very emotive, and there's pressure coming from the accountants, from the lawyers, because what they want to do is that they want instant gratification. They want everything to be done now and now, because as earlier on, as Faisal said, they don't know exactly where the assets are, where what the PIN number is, the entire process when bank accounts are frozen. So what we're finding is that these people become very emotional, and they lose focus in the particular business. Now, the other thing that's happening is that these family members that's coming to the business, they're not financial literate to what we require them to be in, financial literate. Many of them were in school, were in university many years ago. They knew about the basics, but adding to Faisal's list, you need to get your family to understand what is budgeting, uh, the value of money, the basics of a bank account, how the bank operates. So these are the minor things that family business new entrants and at this emotional shock stage they need to know about. And what we're finding is that there's a lot of issues regarding the understanding of business. and the basics of business. Now, when family business people, when the sole proprietor passes away, or a partner passes away, or the other partner might be an active partner or a sleeping partner, but there's a lot of miscommunication that occurs between the families, or if it was a sole proprietor or it was a sole shareholder, between the family and the management team. So what we are doing presently in our interventions with accountants and other service providers, we've come up with a tool. And in this particular tool, we go to the basics of the entire business. From the time the business starts, how goods are purchased, the entire value chain, who is your customer. We go to this person, and the families begin to understand the importance of these basic interventions. So they become a very high level business literate. So these are the interventions that we are doing presently. And all these interventions are being done through books, and these books are available online. So inshallah, this is what I really wanted to tell you at a very high level.
Shukran. Thank you, Ahmed. Thanks for that. I'd like to now ask Raeesa, Bayat to talk to us about the challenges that the individual faces, especially the spouses or the heirs that are left behind, especially opening banking accounts and all the different challenges that they face, for example, creditors and that type of thing. Raeesa?
Assalamu alaikum and good evening, everyone. I'd just like to thank you, Mr. Suleman, and as well as the Manara Chamber of Commerce for allowing Albaraka Bank to be a part of this initiative. I think the previous speakers have given a lot of valuable, beneficial advice thus far. I'm going to try and keep it brief. I'm going to give you a very brief overview from a banking perspective as to what happens to your personal and business accounts when a family member or when you pass on, and just a few recommendations as to what can be done from a business continuity perspective, bearing in mind the challenges which we have noticed some of our clients experience at the bank. Unfortunately, it is a sad reality, but we have had clients recently pass on, and we are having to now get the accounts of these individuals in order. So I'm just going to give you a little bit of information on how that works. I'm going to start with your bank accounts and how your bank accounts are impacted should you or a family member pass away. So in terms of your individual accounts, and here I'm not talking about companies or CCs or the like, I'm talking about your personal account. This account will be freezed immediately. So once the bank is notified of a client of ours passing on, and even if this is unconfirmed, the bank is linked to the Department of Home Affairs platform. So the bank will obtain confirmation and will verify this information via the Department of Home Affairs platform. And once verified, the account is frozen immediately. So zero activity is permissible on that account. I would just like to highlight and emphasize that no one has access to this account. So not even any authorized signatory on the account. So even an authorized signatory cannot withdraw or transact on your transactional banking account once it's frozen. What would then happen is that the process of executorship would follow, and Rumana did explain this a bit earlier on in the presentation. The bank would also require a copy of the deceased death certificate. We would ordinarily also request a letter of executorship as well as FICA for the executors. As Rumana mentioned earlier, regulation does dictate that an estate-late account be opened with a financial institution, and this is primarily for purposes of managing the distribution of the estate. Once this estate-late account is opened, the funds can then be transferred from the account holder's bank account to the estate-late account by the executors who have been duly appointed. I'm now going to just touch on entities. Now, obviously, there are various forms of legal entities. If you look at trusts, and Rumana touched on this earlier on, and the importance of knowing what your trust entails. If your account is held in the name of a trust, the trust as well as the clauses and rules within that trust will govern what will happen to your account. So if, for example, there are 3 trustees on trust ABC, and generally this is the norm, the bank will then review your trust deed, and dependent on what has been stated and dependent on the clauses in that trust, the remaining 2 trustees may be able to transact on that account. Just to take note that as much as the trust may allow for the remaining two trustees to transact on that account, the bank's resolution, and this is where the authorized signatories are appointed, may need to be amended. So if the bank resolution currently authorizes any one of the three trustees to transact on the account, then that's fine. However, if the current bank resolution on record only indicates that the deceased individual be authorized on that account, this is also fine. However, a new bank resolution will have to be signed. If the account holder is a company, and if there is more than one director, a similar process would apply wherein the remaining directors would have authority to transact on the account. Again, bearing in mind that a new resolution would need to be signed, and the bank will request for updated registration documents for FICA purposes. So this is your SIPC documentation, new letters of shareholding, etc. Just to note again that once an executor has been appointed and a letter of executorship furnished, the executor does have authority to sign on the deceased behalf. Where there is a slight difference though is for a partnership. So if the client is in a partnership, upon death of either partner, the partnership will effectively be dissolved. And if the partnership agreement dictates what should happen in the event of one partner's demise, then the bank will be guided accordingly. However, if there is no partnership agreement in existence, or where there is a partnership agreement, but the agreement is silent in respect of what should happen under these circumstances, the bank will automatically freeze that account until an agreement is reached between the surviving partners, as well as the executor of the deceased partner. From a financing or credit lending perspective, where the client is a director of a business which has financing facilities with the bank will be guided by the existing resolutions on record and will request for updated banking resolutions to be signed. So it follows a similar process as a transactional banking account, where should there have been more than one director appointed and authorized to sign on the company's behalf, the remaining directors do have signing authority for business continuity purposes. Just bear in mind again that updated documents may be required for FICA purposes. In an individual capacity, upon passing, and I think Rumana mentioned this earlier on, all your assets, your income, and your liabilities would form what is referred to as your deceased estate, which is then vested with the Master of the High Court, who then appoints an executor to manage the affairs of the estate. And like Rumana mentioned earlier on, it is the executor's responsibility to liquidate the estate's liabilities and distribute the balance of the estate to your heirs. But of course, I think should you require more information on this, the attorneys would be better equipped to answer questions regarding this process. I'm just going to give you, it is getting a bit late, so I'm just going to try and wrap up, and I'm going to give you a few recommendations or my key recommendations from my experiences within the bank. And I think firstly, and it was mentioned previously, the importance of drawing up a will, specifically an Islamic will for the Muslim audience members. For those of you who do not have an Islamic will drafted as yet, Albaraka Bank does provide Islamic wills. And if you do want to download a will, if you're wanting to update your existing will and you're wanting to draft a new one, you can visit www.myislamicwill.co.za, and I'll put this in the chat just now when I'm done with my presentation, and this will direct you to our website where you can get more information on Islamic wills. My recommendation when it comes to companies would be to appoint more than one director. I think, given the nature of the COVID-19 crisis, it is prudent to identify more than one suitable individual who can be added to the account mandate to mitigate the risk of any authorized individuals being affected by the virus. When it comes to signing authority and signing banking resolutions, again, it is advisable to have more than one authorized signatory so that in the event of one director passing on, there is still continuity and the ability for the business to continue transacting with the bank thereafter. One aspect which is quite common with the businesses which we deal with in particular is the involvement of trusts. And again, like was mentioned earlier, it is advisable that legal counsel is obtained to make sure the necessary provisions are made to ensure business continuity in the event of one of the trustees passing on. I then want to touch on the concept of succession planning. I know that Ahmed Seedat gave some valuable advice regarding succession planning earlier on, but I think I just want to re-emphasize the importance of having a formal succession plan in place. So I work in the corporate office. I deal primarily with businesses, and we see that majority of these are family businesses, which often have been established decades ago. And oftentimes, these businesses were established by the older generation, who often, at no fault of themselves, of their own, tend to hold on tightly to the reins, and they may be reluctant to pass on responsibilities to the younger generation. Alternatively, they may not formally document or structure a concrete succession plan. But I just want to highlight the importance of having a strong senior management and executive team with the necessary expertise, and the necessity to train and groom your sons and daughters to take over when the need arises. You know, Ahmed spoke earlier of giving the younger generation purpose and responsibility, which I think is very important. And lastly, I just want to touch on record keeping. Faizal Suleman gave a very good advice earlier on in terms of what records should be kept in the event of you passing. I think he called it your personal details folder. I was going to call it your in case of death folder, which is a lot more morbid. But I think he covered most of the information that should be included in this. I just want to highlight again and re-emphasize the importance of keeping all the important information in one location together with your will. That's it from me. I unfortunately will have to leave this webinar soon. So if you do have any questions, you may email me, and I will leave my email address in the chat. Jazakallah. Assalamu alaikum.
Alaikum salam. Thanks, Raeesa. Thank you very much. Very informative. Are there any other panelists that want to say anything to I think maybe we get the questions on the chat, and of course, Amina has given the email address where we can have questions, but if anyone wants to ask any questions for the next 5 minutes, I think we can take a few questions. Rumana, do you want to? Anything else from your side?
I think I just want to emphasize the importance of getting the right people to guide you through this entire process. Very often, we don't take professional advice, and we make certain assumptions about our lifestyles, about the complications in our lives. And I think if there's anything to take away from today's presentation, is that one needs to surround oneself with people in the know. Your resource base must be people who understand your circumstances, your lifestyle, so that your will is a bespoke will. It deals specifically with your circumstances. Your trust deed does a very similar thing. Your legal agreements, the management of your business, etc., is very specific to your circumstance. And I think that's been the consistent message very often. And I think we often neglect doing this, and as a result, leave such chaos for the people we leave behind. And that's something we need to work around.
Thank you, Rumana. Faizal?
You know, I think it's been mentioned in terms of choosing the person that's going to assist in running your business. And I think it's very important that whoever you choose in running your business in the event of your demise, you must think carefully that that person has the necessary skills and can continue with your business to protect the value of your business. So, on my side, I think that's one of the critical factors in choosing a person that's going to assist. Yeah.
Okay, Ashraf, any last points from your side?
Yes, I just wanted to add that there is freedom of testation in South Africa. And if you're drawing an Islamic will, I don't know if this is still the practice, but I used to see this in the past. Just a disclaimer, this is not my area of law. But there was provisions made for bequest, special donations, and kafara by the deceased. So that's a special part of the will that has to be executed separately first before the residue is passed down for distribution. So whatever special bequest you make must sit under a different heading. But thank you very much.
Thanks. Ahmed, any last minute points from your side?
So I got, there's a question, there's a comment in the chat about business continuity practitioners. This is very important. Quite a few people that are aligned with us in our practice are business continuity practitioners. We do set up business continuity, the entire process for businesses and mainly for larger businesses. But in the one publication that we've done, which is on dynamic strategies, we look at this very vigorously and to see how the business continues post-debt. And this is something which we are using presently. And it is important for family businesses, whether you're a small operator or a large operator, to have a business continuity plan in place, because this is important. The other thing is that I need to mention, emphasize that financial literacy is very important again. And what's happening presently, we're finding that the moment there's a debt and within 3-4 days, we're getting so-called advisors. They go to their families and start advising them on what they should do with the inheritance and how they should, get their affairs in order. And if you educate your family, if you in financial literacy, you prevent them from fraud, from getting involved in all this, with these fraudsters that would come out with all these amazing schemes. So this is something very important. And also financial literacy, once you educate your family in that, they have this financial freedom, so they can do as they please and they understand the value of money. Because many people today, as our good old friend Gaff always tells me, that many people are inheriting money, but are they well qualified for that inheritance? And this is the challenge that we are facing presently. The qualification of those people inheriting money, and how you need to educate people that are going to be inheriting. If you have a large estate, you need to educate them the value of money and how to go about, investing that money and managing that money. That's very important.
I think, Ahmed, you made some very valid points there, because you suddenly find that you inherit a lot of money, and how you manage that, and how that is able to take you through to the end of your life is important. I know of people that suddenly buy new cars and that type of thing when their spouse dies, and suddenly they have all this money. And you're right, the scavengers are already there to kind of help them manage their funds. The question that I have here is, why is it so time consuming and costly to finalize an estate, Rumana?
There's a process in place, obviously, for purposes of consistency, record keeping, etc. I think firstly, the cost of winding up an estate is charged by the agent or the executor at a fee that is a tariff fee. So it's 3.5% on the gross value of the estate. So for the practitioner, for the fiduciary practitioner who's winding up that estate's not necessarily going to generate a fee for that practitioner within a short space of time. And there's a lot of administrative work that goes in from the inception of taking on that instruction until finalization. So yes, at times the fee would far exceed the time that it takes, and that's in a very simple sort of estate. And from my experience, hardly ever happens because most estates are complicated. When I sort of calculated what it would cost to finalize an estate, a very simple estate where there was just a property, some cash in the bank, and a vehicle, and it took approximately 13 months to finalize, the cost in terms of person hours put into winding up that estate on average costed approximately 40,000 Rand. And one would take into costings into consideration, such as the hours put in, the resources used, the meetings that take place. So it may appear to the family members that this is a large amount of money, but a lot of work. It's very admin intensive. It's a lot of work that goes in, and we have to do it properly, And often it swings and roundabouts. Sometimes the fees are high, sometimes they're low, and we, as practitioners, because it's tariff based, it's something that we have to manage.
Thank you, Rumana. I think we'll wrap up for tonight. I think thank you to the panelists for for joining us at short notice. I mean, we just thought about this over the weekend. I think it's important. It was a very important topic, and they probably, I think we're going to have a follow-up meeting. The recording will be on the Minara YouTube channel, and of course, Amina has put the email address of Minara Chamber. I think Raeesa has also put the email address, and Ahmed has put his website, and Rumana will probably put her email address. But thank you all for joining us, and I think it was a very important topic. I think it's critical that we take cognizance of the different the presentations tonight, because we all kind of just take things for granted. We think we're going to live to a ripe old age, and it's not happening now. People are dying, dozens of people are dying daily. In one of our hospitals, I mean, where you had, 1 or 2 deaths a month, you suddenly find you got 4 or 5 deaths a day. It's really shocking at the moment. And I think we need to take this seriously. We need to take stock of ourselves and analyze our situation, our businesses, our personal information, and ensure that we basically prepare for this. And Faizal has posted the checklist that he's got, and I think it's going to be important for all of us to basically go through the checklist, so that our families are not left in a lurch and kind of confused of what to do. Jazakallah, thank you very much, and good evening from my side.